How to give notice of a hearing. Hi, I'm Darren Findling of the Probate Pro, and we're going to cover exactly the title of this particular video, how to give notice of hearing of a Michigan probate-related matter. Now, the hearing could be a motion or a petition, and these hearings and this entire process are defined by Michigan court rules and Michigan statutes. So it's really critical that you familiarize yourself with the Michigan court rules and the Michigan statutes as it relates to the particular document that you're trying to give notice of. Now again, we strongly urge you to be working with a skilled, competent probate lawyer. This particular process, as with all of the probate-related issues, are complicated. It's not intuitive, it's not easy, nor should this video be a substitution for seeking good legal advice. But we're going to cover the basics, the ABCs of how to give notice of a hearing of a Michigan probate-related issue. Now think about this. You're giving notice after somebody has filed a petition or a motion. That is a request of the court to take some form of action. And it is that petition or motion and the exhibits and related documents that you're giving notice of, as well as the notice of the hearing itself. So everybody that is entitled to receive notice, they're called interested persons or interested parties. Those are defined under the Michigan court rules. Now, specifically 5.125 is one place to look, as well as the other court rules and statutes that give rise to who is entitled to notice of the particular type of petition that you're filing. They would be entitled to the petition or motion, all of the exhibits, the hearing information, the notice of hearing, which tells the date of the hearing, the court location, whether it's Zoom or in person, the date and time, and all the related matters for example, for ADA compliance or any other noticing that needs to be given of their particular rights. So all of the notice or all of the documents need to be served. And that word served is a legal term because we think of the word service or served could mean a lot of things to a lot of different people. So for example, people will say to me, well, Darren, I served them by texting them, or I called them and told them of the upcoming hearing. Well, service in Michigan is a particular process to give due process. That due process, to get due process, you must follow the court rules and the statutes very particularly. And no, texting is not sufficient notice, nor is a phone call. But let's go through the forms and documents and understand the ABCs. In no way is this a substitution for hiring a lawyer. In no way is this substitution for reading the court rules and the statutes and working with a skilled, competent probate practitioner to guide you through the entire probate process. As I've said many times, probate is not simple, it's not intuitive. First, there is a copy of the petition that you filed. So you would have already filed with the court a petition or motion, and it is that document, as well as the notice hearing, that the party is entitled to receive. And in this particular case, there's a scale form, again, State Court Administrative Order Form, PC 562, we're going to cover that. That notice of hearing is a form that identifies all the particulars about where the court hearing is going to be, the date, time, etc. And then after you have served the petition and the notice of hearing, all the requisite documents, and you've either personally served them or done it by mail, or maybe the court has authorized you to do it by publication, then you complete a proof of service. And that is another scale form PC 564. Both PC 562 and PC 564 are available on my website, and I've done videos explaining how to complete these particular forms. It's really important to understand that the forms need to be done correctly. Not only is service required, but giving appropriate notice of the hearing and then the proof of service is critical to do right, because if you make a mistake, one little mistake, you may be waiting weeks and weeks for your court hearing date. You get to court, and then you check in and you learn that you failed to provide notice according to Michigan court rule and statute, and then they adjourn it and you wait and wait longer. The forms, as I've mentioned, as referenced on the bottom of this screen, can be found at theprobatepro.com/probate-court-forms. The scale forms, themselves are available there, as well as videos in which I've explained how to complete each of those scale forms. As we work our way through the notice of hearing, and again, this is PC 562, as identified in the yellow box at the bottom left corner. If you look at the bottom right corner, you're going to see the relevant statutes. These statutes and court rules are like your index, your starting point. So if you want additional information, of course, you could look at MCL, Michigan Compiled Laws 700.1401. You could look at the court rules that are defined there. And at the top, you'll see in highlight yellow, I've identified that this is a notice of hearing. So this is the document with the petition that you're serving to the interested parties to tell them that this is what's being requested of the court and this is your date and time to be able to address the court, object, or consent to that which is being requested. As you can see here, there's a place for your file number, the court name is there. I've also identified in the bottom left corner the form number. The next form is the proof of service. So again, you've sent the petition and or motion, all the exhibits, and you've given the notice of hearing. You then complete a proof of service. This form, PC 564, court rules and statutes are in the bottom right corner to give you additional information. And it asks, what documents did you serve? What actually did you serve? Did you serve it personally, meaning you handed it or had somebody hand the documents to the individual to apprise them of the upcoming hearing? Or did you mail it by first-class mail or registered mail? And then this form allows you to fill in the information depending on how service occurred. In addition, under Section 4, you can identify that after diligent search and inquiry, you've been unable to find particular people, and you have done so by publication, which we'll cover in just a moment, using a particular scale form, PC 617. The bottom is a declaration under the penalties of perjury that the information contained in the proof of service is true to the best of your information, knowledge, and belief, with a signature and a date. And then the bottom left corner is for the process server in the event that you use a bailiff or process server to identify the fee for the service that just took place. So when you get to court, you'd provide to the court the proof of service. Some courts want it well in advance of the hearing. Some will take it the day of the hearing. And that lets the court know that everybody entitled to notice under the court rule and the statute have been given notice of the petition as well as the notice of hearing. As you can see, I've highlighted the area there for the file number and the scale form itself. Again, these forms are available for free. Next document is a publication of the notice of hearing, and it is exactly as it sounds. It's PC 563. It is a document that is used in the event you can't serve personally or first-class mail because maybe the people's whereabouts are unknown. And the area at the top identifies that there's going to be a publication in the legal news of the upcoming hearing, as well as information for the publicating or publishing entity, I should say, below to identify how many times it was published and where the copies were sent, and the affidavit of publication, because that affidavit of publication goes with the proof of service to show the court that you have provided appropriate notice or due process as set forth under the statute, court rules, and Constitution. Next document is a declaration of intent to give notice by publication. It's PC 617, and there's a Court Rule 5.105A3. This is where you're saying to the court that you intend to publish notice of the hearing because the individual's whereabouts are unknown. And then it states, I have made the following diligent efforts to ascertain. So you can't just simply say, oh, they weren't involved in the person's life. I don't need to give them notice, or I called them, or I'm not really going to work hard to try to find the whereabouts of that individual. Notice needs to be provided, and the efforts that you took. Did you send a process server out? Did you do database searches through the internet? Did you try showing up? Did you ask other people? All the things that would have gone on to assuring that you're telling the court that you've made diligent efforts to give notice of the upcoming hearing before you publish, because we know that publication is not a particularly great way of giving notice for somebody whose whereabouts are unknown, because most people don't go leafing through the legal publications each week to see if there may be something involving them. So publication is really a form of notice as a last resort. So all of the diligent effort should be done in advance of requesting of the court notice by publication. Let's talk about some of the other things about noticing and giving notice of hearing as it relates to an upcoming hearing. Under most circumstances, personal service of a petition can be done to the interested person with at least 7 days before the hearing. If you're going to give notice by mail, then it's 14 days. So the hearing date has to be beyond that. And of course, it is a sealed envelope put in the mail and delivered. And again, mail used to be quite reliable, but now it's not. So we really want people to give as much notice as possible to be assured that the upcoming petition is been given to the recipient. It's really critical to follow the court rules and statute, because if you don't, it's really frustrating, as I said before, when you get to court and you can't have your hearing. Don't just drop things in somebody's mailbox or on the ground or near the person. You have to give it to the person if you're doing personal service. Don't use the telephone, Facebook, Twitter, Instagram, text messaging. These are not forms of notice as set forth under the Michigan court rules. And with the notice of hearing, fill it out completely. Give them good notice of the upcoming hearing. And I've seen some people just send a notice of hearing without the petition. That's completely wrong. You have to give them notice of the hearing, not just the date of the upcoming hearing, but what you're asking of the court. It's really important that you sign all of these documents, because if you get to court, they won't honor it otherwise. There are times that you have to give notice to government entities or agencies. For example, the Michigan Attorney General's office is entitled to notice under certain circumstances when there are no known heirs or when there's charities involved. The Department of Veterans Affairs may be entitled to notice in guardianship and conservatorship matters, as well as the Social Security Administration gets notice when they are receiving Social Security benefits, the person that is the subject of the petition. So there are specific rules about giving notice to government entities and government agencies. At the Probate Pro, we are passionate about everything probate. If you have questions about how to provide notice of hearing of a probate matter or any probate-related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.